Good afternoon.
Afternoon, Your Honor.
You've probably already been told that following our oral arguments this afternoon, the court will be participating in a Q&A session with the Florida State University College of Law students at 4 again. Counsel, your schedules permitting, are invited to join the Q&A session as well. With that said, our third oral argument is in the case of Sunseeker Investments Incorporated versus Enterprise Maintenance and Contracting et al. Is counsel ready to proceed?
Yes, Your Honor.
Again, counsel, we've allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. Because this has a cross appeal, I would like to reserve 9 minutes.
Thank you, counsel. You may proceed.
Good afternoon, Your Honors. I'm Jessie Harrell, representing Sunseeker. The issue in this initial portion of the main appeal is relatively simple. It's a pure question of whether the trial court erred in applying the statutory interest rate on the debt that EMC owes to Sunseeker, or whether it should have applied the 18% rate that was found in the note that was entered into evidence and affirmed by EMC's principal, Mr. Hiscock, during the testimony. And in fact, the trial court found in both its initial final judgment and its amended final judgment that it was uncontradicted that EMC executed a document entitled Negotiable Commercial Promissory Note, April 1st, 2007. And that note, which is in evidence, provided for an 18% rate of interest. And Florida law is pretty clear that when there is a contract that provides for the interest rate, that the courts are to apply that rather than the statutory rate of interest. The reason that the trial court got off track and erred in changing its decision in the amended final judgment was because of finding in the bankruptcy court that the parties had entered into an informal lending arrangement. But as we explained in the brief, that finding is not mutually exclusive with the trial court's additional finding that there's no dispute that EMC executed the note. And the reason this is because that was not, the issue of the enforceability of the note was not an issue in the bankruptcy case. EMC had argued in Mr. Tadlock's adversary proceeding that the note showed his fraudulent intent and that it supported its case. And the bankruptcy court found that the evidence of the note was inconclusive, and so it declined to consider that and instead considered the facts of the entire arrangement to conclude that there was an informal lending agreement and certainly arrangement, and certainly some of the aspects of the arrangement were informal. Most of the funds that enabled EMC to purchase London's maintenance and contract were transferred before the note was signed, and on the back end, EMC was repaying money as it had it available and wasn't in regular intervals. And so certainly there were informal aspects to it, but the bankruptcy court never said that the note was unenforceable. It just declined to consider it as evidence of whether Mr. Tadlock had engaged in a fraud. And
I understand. Yes. Enterprise's argument in part, the bankruptcy court's findings that the agreement was informal meant that the promissory note is unenforceable. Do you agree with that?
No, Your Honor. If I'm understanding, because I missed the very first part of your question.
Again, as I understand Enterprise's argument in part, that because the bankruptcy court found the agreement was informal, meant that the promissory note in this case is unenforceable.
That is the position it's taking now. Of course, that was not the position it took in the trial court.
But how do you respond to that argument?
Well, as Your Honor, in that the bankruptcy court's finding of an informal lending arrangement is not mutually exclusive to the finding that there's no dispute that EMC executed the note. And EMC has not challenged that finding on appeal. The fact of the matter is the bankruptcy court was not called upon to determine whether the note was valid or not. It was presented with the note only as to whether it amounted to evidence of Mr. Tadlock's fraud. And the court said it was inconclusive as to that and didn't consider it. And I think if you look at the Middle District opinion, which was an exhibit in this trial court and presented to the trial court, the Middle District was sitting in its appellate capacity when it reviewed Judge Glenn's order, and it explained it really well. At page 16, which is 1016 of the record, said in reviewing Exhibit 44, which was the composite of the note, the security agreement, and the guarantee, the bankruptcy court found it was inconclusive as evidence of Tadlock's misrepresentation of the nature of the funds. And it goes on, having discounted the evidentiary value of Joint Exhibit 44, the bankruptcy court did not refer to those documents in its analysis of the company's lending arrangement. And so that issue was never decided, whether the note was enforceable or whether it wasn't enforceable. The bankruptcy court simply separated that from its analysis of whether the parties had agreed that all of the money that Sunseeker loaned to EMC, both pre-closing and post-closing, was actually a loan.
So, Ms. Harrell,
yes.
So that I understand that, you're saying the bankruptcy court's determination that it's an informal agreement was not commentary on the note, but rather a determination outside of the note about the agreement otherwise. Meaning the behavior that they engaged in outside of the note.
Absolutely, Your Honor. What the bankruptcy court was finding is that the note had no evidentiary value because it recognized that there was a factual dispute concerning when the note was signed and who knew about it. And so it declined to find it had any evidentiary value as to whether Mr. Tadlock had made a misrepresentation as to the nature of the funds loaned, and instead simply found there was this informal lending arrangement and everybody knew about it and there was no fraud. And so since it didn't need to reach the issue of whether the note was enforceable, and it did not reach that issue, it certainly couldn't bind the parties in this action, and it doesn't collaterally stop Mr. Tadlock from arguing that the note is enforceable in this action. And in fact, I'm sorry. And even if there was some sort of collateral estoppel, as we've argued, that's been both waived and EMC is stopped to assert those arguments because it insisted on the validity of the note during the trial. It reaffirmed that it owed interest at 18%. It required Sunseeker to pay documentary stamp taxes during the trial, which costed over $2,000. And if you look at EMC's response to that in its brief, it doesn't argue that the elements of waiver and estoppel haven't been satisfied. It simply argues that they shouldn't apply in a contract setting, which is not the law in Florida. Major League Baseball versus Morisani clearly says that you can waive any right that you have, whether it be by remedy or contract or property. So the concepts of waiver and estoppel do apply outside of that setting. And in the case of Horstadt, which we cited, in that case, someone was waiving their remedy. They had a right to assert certain grounds on remand and gave up that right through their settlement agreement. But I see I'm getting into my rebuttal time. Unless you have further questions, I'm going to reserve the remainder.
Thank you, counsel.
Thank you.
Counsel, since you have a cross appeal in this case, would you like to reserve some time for rebuttal?
I would, Your Honor. I'd like to reserve about 10 minutes for my cross appeal issues. And only 5 minutes on the response right now.
You may proceed.
Thank you, Your Honor. May it please the court, Robert Sirianni on behalf of Enterprise Maintenance, which I'll refer to as EMC. I have 3 very brief responses to provide to the court in reference to the interest rate applied by the trial court in the amended final judgment. The first response that I have boils down to the standard review. In our answer brief, we take issue with the de novo standard review, and we contend that the actual proper standard review for reviewing this issue is actually competent substantial evidence under the Sarasota case. The reason why we're contending that is because counsel is taking issue with a finding of fact presented in the amended final judgment rather than a legal conclusion reached by the court. And our contention is that they applied the wrong standard of review. Secondly, counsel had mentioned an issue about whether or not the trial court required the doc stamps to be paid on the note, and they did not. That's incorrect. What happened was there was an issue about the doc stamps came up during Mr. Tadlock's testimony, and Mr. Tadlock decided to run downstairs and pay the doc stamps, but the court did not order the doc stamps to be paid. Lastly, we're going to rely upon the Zukoski case, and in that case, the court held that another finding of fact or an order from a different court cannot be relitigated in the trial court situation. Our argument there is that the issue of whether or not the note was an informal lending agreement was already decided and ruled upon by the Glenn finding in the federal bankruptcy court. And the Zukoski case says that it cannot be relitigated. And I'd like to reserve the balance of my time for the issues on the cross appeal, if there are any questions.
Thank you, counsel. Ms. Harrell.
Well, Your Honor, I wasn't really prepared to go first on the cross appeal. I understand that Mr. Siriano wants to use his time in that regard, but I have nothing to respond to until he makes his cross appeal argument.
I understand, counsel. Mr. Sirhan?
Yes, Your Honor. Yes, I could discuss the cross appeal issues if that's appropriate at this time.
Well, you should have done it the first time, but we'll let you do it now.
Okay.
And reserve the balance of your time for your rebuttal on the.
Oh, I see what you're saying. Thank you, Judge. I thought I was just talking about the interest issue. Okay. Thank you, Your Honors. We raised 4 issues in the cross appeal. There are, I think, 2 simple issues and 1 more complex issue that results in usury. The first issue relates to the doc stamps, which I did reference in my previous argument. In this case, the court decided in the Silver case, which is from this circuit, this district, that it's appropriate to reopen a proceeding in order for a plaintiff or party to pay doc stamps. We believe that in this situation, the payment of the doc stamps in mid-trial, which was a tardy payment of doc stamps, actually violates the rule in SOMA, which is from the 5th District Court of Appeal. And we're asking the court to follow the rule in the 5th District Court of Appeal, which says that payment of doc stamps prior to the imposition of litigation or prior to a trial must be paid as a condition precedent under Section 201.08. We do not believe that the Silver case actually is opposed to this case. We believe that the 2 cases are consistent insofar as the fact that in this situation, the litigation began 12 years ago and the doc stamps weren't paid for 12 years. They were paid mid-trial. We believe that's inappropriate as a condition precedent to the litigation, both in the SOMA case and the Silver case. Proceeding to my next argument, which relates to the offset, we've argued. There was a $106,000 payment that Mr. Hiscock from EMC had testified to. That testimony is evidence. It was uncontroverted. Mr. Tadlock did not controvert or did not rebut the testimony of Mr. Hiscock regarding the $106,000 payments. And this issue relates to damages. It doesn't relate to an affirmative defense. We believe the Ham case from the 1st District Court of Appeal, this district, applies. And in that case, the argument is that it's acceptable for a party to offset an amount if it relates to damages. And it does not need to be pled under 1.110 as an affirmative defense. And our contention here is that the court misapplied that situation. The payments here were partially, Mr. Hiscock had testified that these were partial payments. He wasn't claiming that the $106,000 is complete, to avoid complete liability. Because it was a partial payment.
So, counsel, it's your position that there was no conflicting evidence below regarding the payments or credits?
Yes, Your Honor. So as far as the $106,000 payments were concerned, Mr. Hiscock had introduced ledgers from EMC, which were supported by the bank statements of the corporation to show that $106,000 payments were made. Our position is that the $106,000 applies to an offset as to damages, not as to the disputed amount between the parties, and as to damages, not as an affirmative defense. So we believe that we did not need to plead it in the counterclaim or as part of the affirmative defenses in the case, but rather the court should have applied it as an offset. But Mr. Tadlock did not dispute it. He did have Exhibit 55 where he did not show the $106,000 payments, but he did not say that those payments were not made. And if I may move to the third issue, if that answers your question.
Sure.
The third issue, again, relates to whether or not Mr. Tadlock continuously owned the shares of EMC. There are two points that we'd like to make in this argument. One is that there was a pretrial statement. We believe the proper standard review is de novo, and the reason for that is that the parties prior to trial stipulated to the fact that Mr. Tadlock did not list shares in his bankruptcy proceedings, and he did not show those shares as assets in the bankruptcy proceedings or in a K-1. Because the parties stipulated to the fact that those he did not continuously own the shares in a pretrial statement, we believe that the proper standard review is de novo, and the trial court also misapplied that finding in the amended final judgment. Finally, leading back to the usury issues that we've raised in our appeal. As far as the usury issues are concerned, this is a counterclaim that the parties had positioned at the lower court. We believe on page 32 of our brief, we outline an economic analysis of how the payments made from EMC to Sunseeker and Mr. Tadlock or Usurious under section 687.03. And the reason why we positioned this argument is that the payments exceeded 25%, which is the statutory rate for lending. And it actually came out to 25.32%. And in this situation, Mr. Tadlock acted both as the borrower and as the lender for the April 1st, 2007 loan. We believe that the April 7th, 2007 note is intertwined with the SBA loan, which came a day later, and that it was actually used by the SBA under paragraph 4 to serve as a basis for an equity position in the corporation. Since the total amount exceeds 25%, we believe that the loan is usurious, and that under the Jersey Palm case, we're asking this court to dismiss that note as being usurious. I'd like to rest the balance of my time for rebuttal, if there's no further questions.
And thank you, counsel. Ms. Harrell, you may proceed.
All right, let me unmute myself there. Thank you, Your Honor. On the main issue, I'll briefly say we believe that the standard of review is de novo. The correct question is whether, given the court's findings of fact, it correctly applied the law as to which interest rate should apply. There is no factual finding that we are challenging. If I misspoke and said that the trial court required the doc stamps, I apologize. What I meant was that EMC insisted on the payment of the doc stamps, which is another reason that they are now stopped from claiming that the note is not enforceable. And as to the Zukovsky case, that case actually says that collateral estoppel bars relitigation of the same issue between the parties, which has already been determined. And at no point in the bankruptcy order did it ever determine whether the note was valid or not. And so there is no bar to relitigating that issue. Turning to the cross appeal, I think we've laid out pretty clearly in our briefs our position as to payment of the doc stamps. During the trial, the trial counsel explained to the trial court at the time that under the current version of 201.08, it is not a condition precedent to have to pay doc stamps on a promissory note. And he cited to the case of Glenwright Homes, which we've cited in our brief, which deals with the current version of the statute. And the cases that Mr. Sirianni is citing do not deal with the current version of the statute. The current version of the statute requires payment of doc stamps on secured instruments that have been recorded in the public records, and that is not what this note is. It was never recorded. It's not a security instrument, and Glenn Wright Holmes explains why that is no longer a prerequisite under the statute. But even if it was, Mr. Tadlock requested permission to put on the evidence during his case in chief, and it was only at the insistence of EMC's counsel that the trial proceeded, and the doc stamps were paid during a recess, and then that evidence was introduced in Sunseeker's rebuttal case, and there was no objection to it being presented at that time. As to whether the trial court improperly failed to credit EMC with additional payments, I think the most significant thing that this court should recognize is that the bankruptcy court did make those findings, and as to how much was paid by Sunseeker and how much EMC repaid. And that was critical to the case because EMC was trying to show the amount that it claims Mr. Tadlock embezzled from it. And so it was necessary to show the payments that EMC made to Sunseeker to prove that claim. It had every opportunity to put on this evidence, and it did not. And the bankruptcy court specifically found how much was paid, or how much was advanced, how much was repaid, and then the trial court adopted those findings. The assertion that Mr. Tadlock did not contradict that testimony, that's the first time I'm hearing that. I didn't see it in the briefs. And in fact, I'd point out that on page 6 of EMC's initial brief, they say that the testimony of Mr. Tadlock and the testimony of Mr. Hiscock on the payments exchange between Sunseeker and EMC is contradictory evidence on the same issue. They admit it in their initial brief that this was a disputed issue of fact, and that leaves the trial court as the fact finder in the superior position to resolve that issue. And we, I've cited the Department of State versus Fabiano for that proposition that they're in the best position. And I also made a tipsy coachman argument that as to the collateral estoppel of being able to reassert the amount of the payments. And I think it's significant to realize that the ledger that EMC introduced as an exhibit in this trial was dated well before the bankruptcy trial, and that at the bankruptcy trial, EMC agreed to the amounts that Sunseeker was asserting. They introduced a joint exhibit as to the ledger, and even the appellate court recognized in footnote 4 that EMC on appeal did not dispute the amounts. And so for them to come in now and say, oh wait, we missed a payment, and have no canceled checks, no wire transfers, any paper to back it up other than a bank record, which their own Mr. Hiscock testified, some things didn't even match up, and he had the burden of proof. I mean, there was no proof to support it, and the trial court got to resolve that factual discrepancy. As to the third issue of whether Mr. Hiscock continuously owned his shares, I think you only need to review the stipulations to see that there was nothing contrary to that. Mr. Tadlock did attempt to transfer his shares to EMC, to Sunseeker, and he was unsuccessful. The parties stipulated that EMC never recognized the transfer on its books, which would have been legally required to make the transfer. And they also stipulated that the K1 did not go to Sunseeker. It went to Mr. Tadlock, which meant EMC recognized that Mr. Tadlock was the owner of the stock. There's nothing contrary about the trial court's finding. As to the usury defense, the trial court well understood that Mr. Tadlock's shares were collateral for the loan. There is nothing usurious about having collateral. The Valapian versus Cruz case says that a loan agreement is not usurious when a payment depends on a contingency, and that's clearly what collateral is. It's a contingency. Mr. Tadlock owned the stock. Sunseeker had no ability to get that stock unless there was a default. While he was president, there was no default, was no attempt to get that stock, and it wasn't until 2 years later that he attempted to transfer the stock. The fact that he misunderstood the legal ramifications at the time of his bankruptcy did not divest him of ownership, and there was certainly no evidence presented at the trial court of any benefit that he or Sunseeker received from that mistake in the bankruptcy court. So Under the, the trial court clearly found that this was, sorry, I see I'm running out of time, that this was collateral, and that finding is fatal to their argument of usury. Thank you, Your Honors.
Thank you, Ms. Harrell.
Thank you,
Now,
Honor.
Mr. Ernie, you may conclude.
Thank you, Honor. As far as the doc stamp issue is concerned, there's a public policy reason why doc stamps need to be paid prior to litigation. The reason why is because it would send a message to lenders that borrow that they would not need to pay doc stamps until the last minute, and that would avoid tax liabilities and so forth. So I don't think we want to send a message that doc stamps don't need to be paid. I think that the parties should pay them. They should pay them ahead of time. They should do what's required of them. And we believe the Silber case that this court issued said that it's not appropriate for parties to change facts mid-litigation. And that's what we believe happened here, was that the facts changed mid-litigation by Mr. Tadlock paying the doc stamps. Next, as far as the $106,000 offset is concerned, the trial court found that the $106,000 didn't matter to the case, not because it was disputed or not because it was not proven correctly, but because we did not put it as, the parties did not put it as an affirmative defense. Again, because it relates to damages and a partial payment, and we're not trying to avoid liability, we believe the $106,000 should have been taken into account. Last, as far as the use reclaim is concerned, the paragraph 4 of the SBA loan says that the money provided by Mr. Tadlock was equity in order to obtain the April 2nd, 2007 loan. And on page 643 of the record, Mr. Tadlock does provide testimony, which we put in our reply brief, that does discuss his equity position as part of the SBA loan. With that, I'd like to rest and thank you for your time, Your Honors.
And thank you, counsels, for your respectful oral arguments this afternoon. This concludes our oral arguments for this afternoon. Again, counsel is invited to join us for the Q&A session with the FSU College of Law students at 4. We stand in recess.
Thank you, Your Honors.